Good morning, or I guess afternoon. I'm on Pacific Standard Time, so for me it's 10 a.m. Good morning, and thank you so much for joining us today to talk about prosecutorial discretion, which is definitely a hot topic in a lot of the issues that we're seeing across the country right now with civil unrest and all of the protests that we're having around police accountability and the role of the prosecutor. Today we have Melba Pearson, Andrew Feldman, and Professor Nora Whitener that's joining us today to discuss this. I'm going to hand it over to them to introduce themselves and give you a little bit of a background. And then we're going to go through and we're going to have Andrew Feldman get us started with the discussion this morning. So Melba, if you could please introduce yourself.
Well, good morning or good afternoon, everyone. My name is Melba Pearson. I serve as the Director of Policy and Programs for the Center for the Administration of Justice, housed at Florida International University. I served as a prosecutor in Miami-Dade County for close to 16 years, and also served as the Deputy Director of the American Civil Liberties Union, the ACLU of Florida, for 3 years before coming to this role.
Thank you. Andrew, if you could please introduce yourself.
Thank you, Gloria, and thank you for everyone at the ABA for including me in this panel. My name is Andrew Feldman. I'm a white-collar criminal defense attorney with an office in Miami, Florida, and my practice really is throughout the United States, and that's all I've been throughout my career as a defense lawyer. Thank you.
Professor?
I'm Nora Whitener. I'm the Royal Steinheimer Professor at Washington Lee University in Virginia. And my background is in criminal justice research and writing. And I have spent the last year really focusing very heavily on the role of prosecutors in our criminal justice system. I'm the lead author of Sentencing Law and Practice, which is a major case book on sentencing. And I'm an editor of the Federal Sentencing Reporter.
Wonderful. And so, Andrew, I'm going to have you get started on today's discussion on prosecutorial discretion. As a defense attorney, you represent clients in federal court, mostly practices in federal court, and you practice in different jurisdictions and have experienced a lot of cases involving different prosecutors in different jurisdictions and have broad experience as to how prosecutorial discretion impacts your client and your ability to advocate in the case. Can you share with us your perspective on how prosecutorial discretion has impacted your advocacy and specifically some of the clients that you represent in your practice?
Sure, and thank you for the question. It's obviously something we could talk a lot about, but sort of to answer your question, what I suggest is sort of going through my top, I think it's a top 9 list, not a top 10 list, in terms of prosecutorial discretion. And, obviously, prosecutors have tons of discretion even before a case starts. So let's start with that. Number 1, they have discretion with respect to what offense, if any, to charge a client with. There are specific DOJ guidelines that talk about, alternatives to criminal prosecution. If you look at the Varsity Blues case, if you look at a case that I'm involved in right now, talking about horse racing and doping horses, if you talk about the FIFA case from years ago, these are all cases, and some of the COVID-19 cases, we all hate COVID-19, but some of the COVID-19 cases, you have to ask yourself, do these really need to be criminal cases? Are these situations where the prosecutors could have gone through an administrative process or even a civil process to go there? So it starts at the very beginning with, should we charge this as a crime? They have a ton of power there through the executive branch. Then it, trickles down to, okay, before we bring you into court and arrest you, how are we going to do it? So everyone's talked about the Roger Stone example down here in South Florida, where many different law enforcement agents that were all armed descended on his home. Well, that's a nice high profile example, but I have a sort of a compare and contrast from my own experience, which is I had one client in Atlanta that the government had known about for 8 months. They'd known that she had flown down here to visit me and to confer with me as counsel. And guess what? Instead of just arranging for her to surrender in the Southern District of Florida, they arrested her in her home in front of her kids and her husband. And then they put her in a paddy wagon and drove her to an hour and a half to Atlanta to have a hearing there. And then, of course, to arrange one here. that was just unnecessary, but they have all the discretion in the world about whether or not they're going to let your client surrender. I had another case in Northern Florida that did the exact opposite. Hey, we're going to arrest your client today because he's been indicted. Can you bring him in? Sure. And so that happened. And it goes beyond that. Once you're in court and you've been arrested, you have what's called a pretrial release hearing, or you're entitled to it if that's going to be something that's sort of, up for a court to decide. And of course, that's a key moment in any case. Is your client going to be in custody when you represent him or her, or is he going to be out of custody? And they can make even conditions of pretrial release so onerous. Lots of my clients are professionals, accountants, doctors, people in the securities industry. So they could say something right off the bat. You're not allowed to practice medicine, or you're not allowed to trade securities. Okay, so now a year goes by. There's a presumption of innocence in the United States, and you can't even do your job and earn income while you're waiting to prepare for trial. That's another place where the prosecutors have a ton of discretion. And they may even say something like, hey, we're willing to not move for detention of your client as long as he or she agrees to cooperate. I have a huge problem with that as a defense lawyer, but that's another area where they have a lot of discretion. And sort of jumping into the, huge area where they have discretion, of course, is pleas, right? So we are a country, at least in the federal system, that's a plea and sentencing country at this point. About 98% of cases are resolved through plea agreement in the federal system. Keep in mind, a lot of those are guns, firearms, and immigration cases, but a ton of white collar cases as well are resolved through plea agreements. And the type of plea agreements and the type of plea offers and sentences that are open to clients before a trial, it's tremendous, the discretion a prosecutor has. You start from basically 0 to 5 years to 15 to 20 years. And we're talking about the same conduct. You could be talking about someone that's high up in the totem pole in a conspiracy versus someone that's low down. The person that's low down may say, hey, I want to exercise my Sixth Amendment right and go to trial. And somehow, some way, because the person high above pled out early, they end up with a similar sentence. I just don't think that was what everybody had in mind in setting up our criminal justice system. I could talk about pleas, and hopefully we'll talk about that a little bit later. But the other areas where they have a lot of discretion is discovery. The way in which discovery is produced is prosecutor specific. When it's produced is prosecutor specific. And you have what's called Brady, Jenks, and Giglio, which absolutely has to be produced to the defense. But the question is, do you give it to me at the beginning? Do you give it to me at the middle? Or do you want to get really nasty, especially with Jenks, and wait till your actual witness has testified and then give it to me when they're off the stand? I've actually never had that happen before, but colleagues of mine have. Because if you look at the rule, that's when they have to turn it over. And for anyone out there that doesn't know what Jenks is basically a statement made by a former statement made by a witness that the government's calling, which of course you would want as you're preparing for trial. So the rules sort of enable it, but the prosecutors have all the discretion in the world to sort of have that flexibility to, I don't want to say manipulate them, but work within the rules to provide you what you need to thoroughly investigate your defense and your case for your client. Similarly, you get an exhibit list and a witness list in the federal system. And the question is, when are you going to get that? A pretrial order written by the judge may say, okay, the government has to turn it over 2 weeks before trial. If you have a case with 1 million documents, you're going to give me your exhibit list 2 weeks before trial. I mean, that's going to infect the entire rest of the case. So that's another area where if you work with the prosecutor and you guys are professionally courteous with one another, perhaps you get the witness list and the exhibit list 2 months before a trial like that, or even 3 months. But in my experience, the only way that that's done is if you agree to a reciprocal defense exhibit list shortly thereafter, which is fair. But again, the government has the burden of proof in the United States, so we don't really need to put together any defense exhibit list or witness list. And then finally, sentencing is, of course, goes hand in hand with pleas, but the sentences that folks get if they go to trial and exercise their Sixth Amendment trial rights and lose, just across the country are terrible. And the positions that the government will advocate for if someone hasn't accepted responsibility and pled guilty at the time that they're expected to, are not so great. Plus the federal sentencing guidelines, they enable it, they encourage it, because you have the acceptance of responsibility. You get 3 bad points off your sentence if you come in early and say, hey, I did it. And that's sort of all part of what I would call the trial tax. Sometimes you may look at the difference between going to trial and not going to trial, and the spread between, if you were to go to trial and lose and if you were to plead guilty is not that heavy. But in most cases it is, and in most cases the government and the prosecutors sort of have the discretion to determine how wide ranging that spread is. And just on that note, to sort of finalize this list, if a client determines that he or she wants to cooperate, of course, again, the rules have built in the discretion for the government. You have government sponsored motion for cooperation. So thank you for the question, Gloria, and I look forward to discussing these issues further.
Thank you, Andrew. Melba, as a prosecutor, you served in a very large county jurisdiction, a big office with a lot of cases. How did you personally, both as a prosecutor yourself, prosecuting cases, but then also supervising your staff attorneys that were charged with making these decisions and exercising their discretion? Can you speak to some of the issues that Andrew brought up in his discussion?
Sure, absolutely. So again, it's great to be here with all of you and to be able to chat about these really important issues. I also serve as co-chair of the Prosecution Function Committee, and I'm a past president of the National Black Prosecutors Association. So my viewpoints are not only just my personal journey, but also watching very closely the journeys of others and hearing from different offices around the country what their experiences are around this issue. And recently we put together a book called Can They Do That? Understanding Prosecutorial Discretion, which Nora was kind enough to author an amazing chapter on this topic. So personally, my journey is a little bit different from the standpoint that I worked at a very large office. The Miami-Dade State Attorney's Office at the time of my tenure had about 400 attorneys. It's probably down to about 350 right now. And so there's the big city prosecutor experience with how you learn and how you develop your craft, as opposed to the smaller, more rural jurisdictions where you may find more uniformity and a little bit more of a hands-on approach because of the fact that the offices are so small and as a tighter, more cohesive team. So looking at my journey personally, when I joined the Miami-Dade State Attorney's Office, I did receive, like the rest of the incoming class, about a month-long training, which gave us a basic understanding of what prosecution was about. But where you really learned was on the job. And you learned by being in different situations. Now, the issue that often arises, especially in larger offices, is that you have different supervisors, and there's not necessarily uniformity in how pleas are being extended or what sort of protocols are acceptable, when discovery should be turned over, right? Like there's always an understanding it needs to be turned over in a timely manner, but what that means may vary from courtroom to courtroom and from prosecutor to prosecutor. So I found that I became more comfortable in exercising my discretion as I became more senior in the office. Obviously, in your beginning phases, you're very concerned about your performance. not, and let me rephrase that. It's not saying you don't always care about your performance, but you're obviously new and you're lower on the totem pole. So you're a bit more fearful of, getting into trouble or doing the wrong thing. And so many times you learn about your discretion sort of on the fly. Sometimes you're hearing from your supervisor, for instance, sale means jail. So whenever there's a narcotics case that involves a sale, automatically it should be an incarceral plea as opposed to looking for other alternatives. So as you sort of evolve and grow and go to trial and sometimes lose cases, which is part of the process, you then start to realize when cases were good, when cases were bad, maybe what police officers have trouble with, telling the truth, to be very blunt, or maybe sloppy in the way that they do their investigations, and others that, if they come to you with evidence in a file, you can take it to the bank all day long, right? So having those experiences is what teaches you, okay, just because I see these facts, I need to not make any assumptions and ask more questions so that I can come to a better plea agreement. I have a better understanding, or I don't have a situation where I put a witness on the stand and their testimony backfires because I didn't ask the right questions. And then also, another thing that I learned is that when you start filing your own cases, you use your discretion a lot more robustly, right? Because many times offices will have a more vertical approach to prosecution, which means one person files the case, it gets passed off to someone else, and then maybe multiple prosecutors before the case actually goes to trial or is resolved via a plea. But when you have and get to a point in your career where it's more of that horizontal structure, where you file the case and keep it to completion, once you've had that experience of filing an awful case and being stuck with it throughout, you then learn very quickly what cases have merit and what cases do not. So you start to exercise your discretion earlier in the process to make sure that you're filing better cases and that you're getting better outcomes in the end. But at the end of the day, I think as you become more senior and more comfortable as a prosecutor, more comfortable with case law, more comfortable with the day-to-day of the courtroom, you start to exercise your discretion more, and you're more likely to drop cases because you feel empowered. You feel like you have the ability to do so, and it won't be, you'll get in trouble with your supervisor, or the judge starts yelling at you because you're new and you don't quite know what you're doing. When you're more senior, you know how to phrase and what reasoning to put forth in order to justify a particular outcome. So that's something that comes with time. But I think what's very important is having uniformity and protocols that are clearly communicated by the elected prosecutor down to the supervisors, who then communicate it to the line prosecutors. Because once the line prosecutors have a robust understanding of what's expected of them and what their options are, that every case does not have to result in incarceration, that actually the majority of the cases should not result in incarceration, and maybe there are other options, as in, for instance, mental health court, or a drug court, or drug treatment programs, other community-based programs that could address the root causes of crime rather than relying on incarceration and people returning to our communities with the same initial problems which cause them to reoffend. Those are things that need to be explored as early as possible and communicated so that the prosecutors are learning earlier and feeling empowered to make better decisions that could impact our community in a positive way.
Thank you, Melba. And turning over to Professor Ben Whitener, you sit in the space where you're doing national research on these issues, and you're also, because you have law students, you're also helping train the next generation of, a lot of lawyers come out and going to a public defender's office or a prosecutor's office oftentimes our first jobs for law students that are graduating from law school. With your national research lens, having studied this across the nation, and I think Melba shared her experience in a very large metropolitan area, but there's also offices in like rural towns, but really small offices that have less resources. Can you kind of like share with us, based off of what Andrew and Melba have shared with us, your perspective, both as a professor training up and coming new prosecutors, as well as your research on the landscape of prosecutorial discretion across the country?
Oh, thank you so much for that question. I'm looking forward to getting into some of the nooks and crannies of that. But first, let me thank the ABA and all of you on this call for participating in this conversation about prosecutors. And really everything that Elba and Andrew have said resonate with me. I think one of the questions that Andrew was really getting at is, how do we get here? And really the most interesting thing I think about this topic is that it's been with us forever. There was a big national study in the 1930s on prosecutorial discretion. And the writers of that study actually warned of the power of prosecutors. And what happened to that study? It ended up on a shelf. Nothing happened. And in the 1970s, we turned to judges are the problem. They're too lenient. They must be restrained. So there was all this legislation, especially on the sentencing side, to restrict the discretion of judges. And the funny thing about the criminal justice system is you push down the discretion here, it suddenly jumps up on the other side. And that's exactly what happened. So prosecutors, I would argue, sometimes intentionally, sometimes inadvertently, got a lot more power. And that is certainly true in the federal system, but it's also in the states, especially when there are mandatory sentences that are in play. Now, I think what that has done, and Melba was kind of pointing to that, is we have this sense of the prosecutor as harsh, right? It's the prosecutor who asks for imprisonment. It's a prosecutorial win when there is a conviction and a prison sentence. And the new progressive prosecutors, and Melba would have been one of those, I think really challenged that paradigm. And the public has a problem with that, and a lot of the judges have a problem with that. We actually saw this in Virginia here, where a number of the new prosecutors wanted to not prosecute small possessions of marijuana anymore before the state officially decriminalized it. And the judges were refusing to dismiss these cases. Now, it took the state legislature just stepping in and saying, no more of this. The prosecutors have the right to do this. But this is I think, really reflects the stunning assumption of what we think of prosecutors. Harsh, never lenient, always kind of law and order. And what we don't understand is that there is a lot of bandwidth in what decisions they can make. And I think Melba and Andrew gave us lots of great examples of how this can happen and how these decisions come out often differently when you have different prosecutors. I should say, besides my kind of research, I also sit on our the local prosecutor in Albemarle County, Virginia Citizens Advisory Committee. And he and I just earlier this week had a long conversation. And let me just give you one example. So before he came to office, there was a plea agreement worked out between his predecessor and an offender. The man had failed to register as a sex offender. He had a conviction that was 30 years old for a sex offense, but was still required to re-register. His home was registered. He hadn't changed. That was on the registry. He had switched jobs. And he knew often that when he had to re-register with his new job, he would lose his job. We're talking about low-income jobs. He really needed that job. And so he kind of chose pretty much intentionally not to re-register. And he was found out. That's a criminal offense. And he got like the best bargain you could possibly get. 7 months in jail and a guilty plea, and therefore a new conviction. Our new prosecutor came in. He looked at this case and he said, who are we serving with this sentence? Who is actually benefiting from this? The man is definitely going to lose his job. With the income level that he sees, he worries the man is going to lose his house and therefore his housing and livelihood. He is no threat to the public, nothing other than one minor traffic offense in the 30 years since he'd been released from prison. So he and the defense lawyer went into court and said, we're dismissing this case, like out of the bargain. nothing more will happen. Nope, no guilty, no jail sentence. The judge was shocked, as I said, not used to that from a prosecutor. But was that the right and the just decision? Yes, because there was nothing, there was really no benefit that accrued from this. And that's the power that prosecutors have. I mean, that is a stunning reversal of the outcome of this case. Now, Gloria, you said, how do you teach that? Well, I think some of these things you have to bring in prosecutors who talk about these types of things. But even with my students, I often see the same reluctance that we see in the public. A prosecutor did that? How is that possible? Isn't that like not right? Well, is it? I mean, that's, I think, when we have to start talking about what's the greater value, what's the purpose of the system, and we often forget that. We're so pulled into our rules and our appellate court decisions that we don't ask these big questions anymore. And I think the prosecutors who have the luxury to ask these, and this is clearly the head of the office. I mean, we're not talking about a junior prosecutor. I think they have to ask these big questions. Now, the problem with my students sometimes is that they think they will step in and they're going to make these calls on day one of a new job. And I'm sure Melba will smile about that, because that's not how this works. But office culture matters so much. That prosecutor is going to bring up a very different crop of junior prosecutors than his predecessor did. And I think that's why it's so important. And I try to talk to my students about, you know, what is it you want to look for in these interviews? What tells you what prosecutors are going to be like? What's the training you're going to be getting? It's not a perfect predictive model, but at least I want them to think about office culture as a very important function of their training. So let me leave it at this, because I think we have a lot to discuss as a group, and I'm sure there'll be a lot of questions as well.
This is a great segue. Thank you so much for your part. I think you kind of framed our next part of the discussion is, I think that having been a prior prosecutor myself and a defense attorney, I've been on both sides of I guess, of the courtroom. One of the things that's really left out in prosecutorial discretion and even in prosecuting is the impact that prosecutors have on people's lives and their families. And I think all of you touched upon that, for, I guess, as a prosecutor, you have a caseload and you're going to be going to court and managing all these cases. And as a defense attorney, you also have a caseload and you're doing the best you can to advocate for a client. But while these cases are being processed, whether they get dismissed, whether they get alternatives to a therapeutic court, whether they get dismissed, whether they get some other sort of outcome, these people's lives are being impacted. And a lot of the times it's people that don't have a lot of socioeconomic status. There are people that are already struggling to begin with. So Andrew, you kind of touched upon a little bit on well, quite a bit earlier on your top 9 issues that you encounter. How do they personally, in your experience, how do you see prosecutorial discretion benefiting or detrimentally impacting the defendants that you are representing?
Well, I guess I'll try to answer. It's a good question. I try to answer that question by using sort of concrete examples. Just thinking about my clients, who a lot of the time, again, are professionals, and a lot of time are in the healthcare universe, whether they're pharmacists or doctors or people that just own a healthcare facility. At the very beginning of the case, what the government wants to do to assert some type of pressure is to stop them from work. And if they're out of work and they have children and they have a significant other who depends on them, then of course that directly impacts them. So I understand the government's position, and that they may think that, because judges have let them get away with it for decades in the federal system in terms of just what they think is a reasonable pretrial condition of release. I understand that they may think that that is reasonable, but again, there's a presumption of innocence in the United States, and folks need to be able to work, especially if there's no harm to anyone from them working. A doctor that's been accused of prescribing too much pain medication, right? And that's the charge. yeah, a judge or prosecutor is not going to sit there and go, oh yeah, he can go right back or she can go right back to doing that. I think that's unlikely, but maybe he or she can go back to practicing medicine, and the condition is he or she can't prescribe, right, any controlled substances. So there's always that wiggle room. There's always that gray. There's always that potential compromise. And again, of course, the judge most of the time on those types of issues is going to go with the prosecutor. So it's almost like, at least in my experience, you got to work that condition out between the parties and then present it to the judge and say, hey, we agreed to X, right? But if you don't agree to X, you're going to end up litigating it. And again, in my experience, 8 to 9 out of 10 times, you're not going to prevail, and that's going to directly impact the client. And then just sort of broadly speaking, any conditions that you have, especially in a case that might not be set for trial for 9 or 12 months, you know, the binary choice that clients have of once they're arrested and charged with a crime or indicted, whether to go to trial or to plead guilty, most clients of mine, they hate that binary choice. Where's, you know, choice 2.5 or 3, right? How do I get out of this? Because in the federal system, the stats that the government has against clients are just so tilted in their favor. And of course, no one wants to go into federal court and say, yeah, I did it. Please give me a felony. Please sentence me to what is most likely going to be a significant jail term, because I personally believe that any jail term is significant. So it affects them in that sense too. It's like, how do you have the emotional and mental bandwidth to sustain this process for all this time if you have any of these conditions on you? And if you're a flight risk, if you have money in other countries, right? You're not a US citizen, maybe you're a green card holder, but you have citizenship elsewhere, but you could flee to Europe or South America or Central America, right? You have family there, assets, property. Then the conditions that you have on your, that the government's going to impose on you, just in my experience, are going to be even more onerous. You may not even be able to leave your home. You may not be able to leave your home unless you're going to see your lawyer or a doctor. And so, of course, how do you work under those conditions? How do you, you know, support your family? So, you know, speaking to your question, all of this has a direct impact on the client. It just does.
And so, Melba, I'm going to turn it over now to you in response to what Andrew has shared with us. Brian Stevenson, the author of Just Mercy, really talked about that one of the biggest impacts that he had was proximity, is having proximity to the actually impacted people in the criminal justice system. And as a prosecutor, because we have an adversarial system where the prosecutor has zero contact and the only information that they have is from the defense attorney. As a prior prosecutor, I found the most ineffective approaches, because I knew nothing about the opposing counsel's client, was the argument of, well, he's just a good guy or they're a nice person. That never really resonated. But how as a prosecutor, not having that proximity to the defendant and all of the struggles that Andrew was describing with clients, with working all these restrictions, that pretrial restrictions that defendants have. As a prosecutor, what did you find most effective in being able to have that proximity, that ability to understand that whatever, as a prosecutor, discretion that you were exercising, how it was both serving justice and public safety, but at the same time was also taking into consideration the fact that these are real people with real lives and real families?
Yeah, so I want to break that question up into 2 phases, right? So there was the first phase, which was me more junior in my career and not having that level of interaction. So many times you heard the same set of facts over and over again. You know, Your Honor, the person came from a family that was broken, the person struggling with addiction. That's, you know, these are all these other factors that cause the person to get into the criminal justice system. And as a result, you know, can we find an alternative way of release, or can we have a lower plea? And, many times, and I will be honest about it, I became a little desensitized because I kept hearing the same set of facts over and over again. And I was just kind of like, so what's the answer, right? I didn't feel like I had a plethora of tools to be able to pick from to be able to help resolve the issues that were being presented. But then in the mid part of my career, I joined what was called the Community Prosecution Unit, where I spent a lot of time in the community here in Miami and really having face-to-face and daily interactions with people who, today is a survivor or a victim of a crime and tomorrow ends up being a defendant, right? Because again, in many under-resourced communities, it's a very fine line due to issues of economics, due to issues of over-policing, due to issues of systemic racism. So when you actually are embedded in a community and you see those day-to-day struggles on both sides, right? So what survivors go through and why they may feel intimidated and not willing to testify against a particular defendant due to fear of their safety and that of their family. And then on the flip side, how defendants end up in the situations that they're in, it kind of gives you a broader view, which is why, one of the things I strongly advocate for is for prosecutors to spend time in the community and not cherry picked, like I'm going to a school to speak and it's, a prep school that is well-resourced, right? But to really work in the community, just on a volunteer basis for a couple hours a month, working with survivors of domestic abuse or, just other people who have a life experience very dissimilar to your own, so that you're able to kind of understand how these arguments come into play when you hear them in the courthouse, as opposed to just hearing it and being like, well, that's the same old song. I'm just going to disregard it and do what I'm going to do. And, I just want to also put a piggyback on some of what Andrew said. Looking at it from the state perspective, which is very different because of the fact that, I'm not going to say all federal defendants, but many federal defendants tend to be better resourced because of the level of charges or whatever it is that's going on. And in the state system, you really are dealing with people that are, facing desperate poverty, right? And many times the people that you see entering the system are there because of mental health concerns, they're there because of addiction, or they're there because of poverty. Very few are there because they are just truly evil. And there is a percentage that's there, and I've looked into the eyes of evil and it's not a pretty sight, right? But the majority of folks, they're there because of some other systemic driver. So when we look at the system, like for instance, the bail system, where, for instance, and I'll give you a very basic example, someone is charged with grand theft, which means you took something, probably in felony level grand theft, let's say you took an iPhone, right? Now there's a standard bond, at least in the state of Florida and many other states, there's a standard bond that is assigned to you. Many times the prosecutor doesn't say anything when the judge is like, okay, standard bond, $5,000, and the prosecutor says nothing about it because, they didn't feel that they really had standing to make an argument one way or the other. But then when you look at that person, they have to either come up with $5,000 or come up with 10% of that to give to a bondsperson. If they don't have that money, right? Let's say they work at a fast food restaurant or a big box store, and they don't have that money to bond out, they are now stuck in custody until such time that their case is pled out or goes to trial. Many times people may feel forced to take a plea because they're like, listen, I've got to pay my bills. I've got to get back to work. I've got to take care of my family. And if we are truly a country of innocent until proven guilty, if someone does not pose a risk to the community, as in the example I just gave, someone who stole an iPhone and this is a grand theft with no violence or anything like that, is that person who we know is under-resourced, we know there's nowhere for them to go, we know they're not violent, is justice being served by them sitting in custody until trial? Or is it better for them to be released on their own recognizance or released to some sort of diversion program in order for them to address some of the underlying issues in their life? And that's where the prosecutorial discretion becomes very important, being vocal when it comes to issues of bail and, pretrial custody issues, being vocal when it comes to diversion programs and making sure there's other paths for making victim survivors whole, but also holding people accountable without necessarily causing all these other collateral consequences that creates greater problems within our society and affects public safety on a greater level.
So I'm gonna now turn it over to Professor Ben Whitener. Both Andrew and Melba just had some really fascinating, enlightening things to share about both of their roles as defense and prosecutor and discretion and the impact on people. In your research, we are the most we have the highest rate of incarceration in the in civilized world. And what in your research, where have you found bright spots where prosecutors can really impact recidivism? And I think Melba, with the example she gave, and also with the example that Andrew gave about clients, in your experience with recidivism and public safety and that balance, where have you seen, or do you have any examples of bright spots in prosecutorial discretion impacting recidivism in a positive way?
Absolutely. And let me just echo what I think Andrew and Melba both were saying, that our criminal justice system really right now is there to address a host of social problems that have really very little to do with crime, or ultimately just manifest themselves in the form of crime because our systems didn't work earlier. So recidivism really kind of addresses that back point again, rather than preventive programs. And sometimes I wish our whole conversation would shift to, for example, mandatory government paid, not mandatory, but government paid universal preschool, which we know has one of the most powerful impact there is on future offending. But that's not what we're going to talk about, right? We're going to talk about how many more people we can keep out of prisons, which is an important conversation, but I really sometimes wish we talk a lot more about prevention. But let me talk about the back end now. Alternative courts are often a good way to keep people from recidivating. Now, let me just also highlight that they are very much an example of prosecutorial discretion. Because if the prosecutor doesn't support them or doesn't start them, they're not going to happen in any jurisdiction. I mean, every judge will say that they need the prosecutor's buy-in, because otherwise it's just not going to work effectively or on a broader scheme. So a lot of those work, a lot of them are probably over-inclusive and under-inclusive at the same time. So by over-inclusive mean, we know we're sending people to drug court who actually aren't addicts, but they will be pleading so that they can get the diversion and then they go to drug court. On the other hand, we also know that there are people we could safely send to alternative courts, but we're not, because we're still thinking that they may be too much of a danger to the public. I actually think COVID-19 may prove to be very helpful in terms of thinking about public safety. So just to use kind of my local jail here as the example, in March, our two of our three local prosecutors who are filling this this jail basically agreed that they would try to divert as many people as they possibly can up front. So bail was basically automatic, own recognizance. If they had serious concerns about someone, they would opt for electronic monitoring, which, by the way, the jail pays for. It's not the individual who has to pay for them. And then on the flip side, they also worked with the superintendent and obviously the defense bar and the judiciary on moving as many people out as they possibly can. They have not had more than a handful of people who have violated kind of these early releases. So that's super encouraging. Well, people may say, well, part of it was a lockdown period. COVID depresses the crime rate. Well, not necessarily. There's a lot of crimes you can commit while you're sitting at home if you so choose. So what you're really seeing, I think, is ways that we could depopulate our jails that we are not even thinking about. Let me also say something about the back end for a few minutes. So prosecutors have the power in the vast majority of states to weigh in on parole decisions in the states where there is still parole. And studies in California have shown that if they weigh in against release, releases debt. Whatever the person has done to redeem himself or herself, it will not matter. The person will not be released. On the flip side, interestingly enough, if the prosecution are in favor of release, it's a neutral. So it doesn't help, but at least it doesn't hurt the person in their bid for a release. So I think it's important for prosecutors to think about that. The people who are being released, I mean, the parole boards have been so stringent on these that I think most prosecutors could really rethink whether a crime 20 or 30 years ago is still the motivating determinant of a release a few decades later. So I think there's the points where public safety will not be impacted when prosecutors just rethink some of their strategies. There are now good public safety studies. I think the one thing we also have to keep in mind is reentry support. Crucial. Without that, people will fail. And I think that's what prosecutors should really support in their local communities.
Thank you. That was a very comprehensive answer to my question. We have a question from one of the participants in the webinar, and I'm going to direct this one to Melba. The question is, what are the limits on prosecutorial discretion? Florida Governor Rick Scott took Aramis Ayala off all death penalty cases, for example.
So I chuckle because I was very intimately involved with this case, especially when I was deputy director at the ACLU of Florida. And in my opinion, this is not the opinion of the ABA or any other entity, but in my opinion, that was a firm overreach by Governor Scott in that particular instance. Because at the end of the day, prosecutors are in the majority of jurisdictions in this country, with New Jersey, Connecticut, and District of Columbia being notable exceptions. But in the majority of jurisdictions in this country, an elected prosecutor is just that, elected by the people of their jurisdiction to govern and to dispense justice in a way that the community sees fit. And so as such, unless, and this is by statute in Florida, if a prosecutor or any elected official is in some way basically harming the community, not performing their duties. Now, this is not supposed to be a difference of opinion, right? It should be like you've been elected to be a prosecutor and you've never shown up at the office from the day that you were elected, right? Like complete dereliction of your duty, or showing up and clearly, you're struggling with intoxication or addiction and not handling that and all of this spilling out into the public. Those are examples of times when a governor should intervene because someone is clearly incapable of fulfilling their duties. But because you disagree with a course of action that a prosecutor has taken, there is no business, there is no right for the governor to come in and override what the prosecutor is doing, because you're basically overriding the will of the voters. If the voters have a problem with what their elected official is doing, they need to vote them out at the next election. And what he did set a very dangerous precedent that we're also seeing with this current governor, Governor DeSantis, who has also removed supervisors of elections from their posts, et cetera, et cetera. So again, it's a very dangerous, slippery slope. So addressing the actual boundaries to prosecutorial discretion, there really aren't any, other than those set forth by, statute. Basically, you have to comply with the laws of the state. But in looking at that particular situation, she was making a decision based on her budget, allocation of resources, and the fact, and she made it very clear in a press conference as well as in subsequent interviews, and she did do a chapter in the book for the prosecutorial discretion book that I referred to earlier. She explained very thoroughly how she came to the conclusion that she was not going to seek the death penalty, that she was looking at, at the fact that, this is not a deterrent to crime, that it does not necessarily bring closure to the families, and that at the end of the day, because of the fact that there's so many appeals and that it lasts for so many years, it is an expense to the taxpayers that she did not see made sense and was a good allocation of the limited resources that every prosecutor's office gets from the legislature. So prosecutors have the ability to make policy decisions within their offices. And it's just very disturbing when you see governors try to intervene in that for political gain.
Yes. So Andrew, I'm going to turn it over to you. As you gave some examples earlier about prosecutorial discretion that was exercised in a way that was positive. And when I say positive, I mean that it was beneficial to your advocacy of your client, and then also detrimental. I think the example that you gave earlier about being able to surrender versus not being able to surrender, and the strategies and the impact that it had on your client and their families. Kind of going off of piggybacking on what Mel was talking about, prosecutorial discretion, there is a slippery slope of reining that in. In your perspective, how do you see uniformity in how prosecutorial discretion can be exercised or regulated, if at all, in a way that would be, provide some uniformity and some consistency across jurisdictions, given that you practice in numerous jurisdictions and have different experiences with how prosecutorial discretion is not currently being really governed in any way?
So it's a really good question, and it's probably enough for another panel. But I'll start by saying you don't really have any rules about this, right? Unless you do something like the prosecutors recently did in the Southern District of New York, which resulted in Judge Nathan issuing a scathing 60-page order about their Brady violations and ordering the entire U.S. Attorney's Office in Southern District of New York to read that opinion. It's good to be clean, right? That unless you do something like that, there's nothing really in the middle, right? So in federal rules of federal criminal procedure, and usually, I mean, I'm not an expert on this, but usually in the state rules of criminal procedure, you don't have a sanctions hammer, right? Like you do in civil cases. Like if you trip up in civil cases, you see this all the time with civil litigants. One litigant will file a sanctions motion against another litigant, whether it's for discovery, for filing a motion they don't like, whatever it is. Sometimes it gets abusive, in my view. So you'd have to rein that in. But there's no such provision in the federal rules of criminal procedure. You have the federal rule 16D, which allows for certain motions, sort of like a grab bag of type of relief you could ask from a court if you think that the prosecutors are misbehaving. But you don't see a lot of those motions unless there's something really egregious occurring, and you're not going to file one of those motions as a defense attorney. In fact, I've never filed one unless there really is something that borders on almost an ethical violation that should be policed by the state bars, right? It's just not going to happen. So the problem is we don't need to go there, but there needs to be something to fill in the gaps. So you have offices like Melba described, and it sounds like she had a great experience at her office and she was a great supervisor when she got to that point. But I've been around the East Coast and the West Coast in the federal system, and it really depends on who the supervisors are. And some of these supervisors are around forever, and so I hesitate to use the word, but some of the prosecutors are indoctrinated, and they have this type of view about how things should go. And just a quick story about how that's really problematic, and how it's really problematic to sometimes be a hero for your agents. There was a youngish prosecutor who she just wanted to believe everything that this agent was saying in a case. I had a client that was cooperating the few times I ever do that. And, she was very truthful and honest, and they kind of, for lack of a better term, they did not do her right on the cooperation when they had their secret committee meetings about how much cooperation to give her. And the reason for that was because this agent had told them that my client was not being truthful. And I said she had been. I'll show you my notes from these meetings. They said, no, you're wrong. Well, what's interesting about that is that agent was subsequently indicted in the Southern District of Florida in Miami. So the government presumably now has egg all over their face on that. But these are the kind of things that can happen when you have supervisors, you have a system, you have people that are just going to do what they've always been taught to do, and there's no pushback. Sometimes you got to be the courageous prosecutor and say, no, I don't think this is right. I was talking to a prosecutor the other day who I have tremendous respect for out in the West Coast. And he, you know, without including any names, obviously, he was discussing with me very openly about agents that he has problems with, and he kicked off his cases. So, you know, part of the answer to your question, I know I'm all over the place, but part of the answer to your question is because we don't have a rule of procedure that is the same as in the civil cases, and because what we have now really puts the onus on us to come up with some facts that are truly egregious, it needs to happen sort of informally and internally within the offices. And one place it can start is with the supervisors and teaching young and you know, middle of their career prosecutors that, like, it's okay to take a stand on certain cases. It's okay to say, you know what, maybe this is not a good plea for this guy or gal, or maybe this search was really messed up and we should just dismiss this case, or maybe we obtained this confession illegally, or, you know, contrary to protocol. I mean, the FBI is still, for whatever reason, not recording post-arrest custodial interviews. The DOJ made a big deal about it. I thought it was sort of a watershed internal decision that you guys got to tape this stuff now. And that was in 2014. That's 6 years ago. What are you doing? Everyone has an iPhone. You can't use your iPhone. It didn't work. So I think that you got to take a stand on some of these issues sometimes, and that's internal. And you know, if I had ever been an AUSA or a supervisor in any office, state or federal, I would have tried to encourage people to take stands on these issues and to be courageous. It sounds like the gentleman in Virginia is the new prosecutor is doing that. So he'll have a whole, you know, bunch of newbie prosecutors who will mature into seasoned lawyers that have perspective. The last thing I'll say about all of this is I've been talking a lot about federal, and there's been a decent amount of discussion about state. You know, in terms of prosecutorial discretion, one of the reasons that they have so much discretion and it's so impactful in federal is, quite frankly, we're behind on all these alternative programs. You don't have pretrial diversion in federal cases. Actually, you do, technically. That's never handed out. There's no drug court. There's no alternative sentencing option. It's either we're going to prosecute your client or you're not. And I think that's an incredible disservice to the community. I'll give a district like New Hampshire years ago. They realized it's a systemic problem with opioid abuse, right? So we're going to lock up everyone that has opioid issues and that are basically killing themselves from addiction? No. The U.S. attorney said, listen, we're gonna carve out a specific group of offenses that are eligible for pretrial diversion in the federal system. So I give him, I think it was a lot of credit for doing that. But like, the federal system needs to do more things like that. So in terms about discretion, one way that discretion would work is to try to think about these alternative resolution programs, even at the federal level, because the federal level is way behind on that, even though we as well in the federal system have a tremendous amount of statutory minimums, which of course apply across the spectrum in a way that is unfair to folks that don't have a certain amount of money, and certainly unfair to folks of a specific type of race. I've seen that over and over again when I go in for initial appearances in bond hearings. You know, these people don't have someone to fight for them, and it's like, okay, you need a corporate surety bond of $250,000. And I think at that point, it's up to the judiciary to do some policing of these offers that are being made by the government, because obviously this person doesn't have that money. There's a flip side of that coin too.
You're absolutely right on that. Yes, and you brought some excellent points about the big disparities between the state and the federal system and how behind the federal system is on these alternatives. We have 1 minute left to go. I just really want to thank all of you. You provided such an invaluable, just rich discussion on this very important topic. And just for those of you participating on this webinar, the book that Melba is referring to, that Professor Ben Whitener also contributed, is the book called the 2020 ABA publication that was edited by Melba Pearson, entitled "Can They Do That?" So that's something you can go on to the ABA store and get a copy if you so choose. But thank you everyone so much for your time, and I hope that everyone got as much out of this webinar as I did.
Thank you.
Thanks so much. And thank you to the ABA.
Thank you, everyone. Thank you.
Care.